What does it mean if, at the end of your medical malpractice trial, the jury feels that your doctor was not careless, yet they still felt compelled to give you $1 million for your injuries and your losses? What does that mean? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It means that they've screwed up the verdict sheet is what it means. It means that they've now destroyed your entire integrity of your verdict. Now, what does that mean? Okay, at the very end of your trial, no matter how long it's lasted, after the attorneys have given closing arguments, the judge gives the jury very specific instructions on the law. And then he goes through with them the questions that they must answer in order to reach their verdict. You see, the jury must go ahead and answer a series of questions in the verdict sheet, and the answers form the basis of their verdict. It's not simply a one-question verdict that says, hey, who do you find in favor of, the injured patient or the doctor? No, that's not how it works. That's not how any of it works. So instead, the first question typically involves liability. Who, if anyone, is legally responsible? And we phrase it this way: was Dr. Jones negligent? Which means, was he careless? Did he violate the basic standards of medical care? If the answer is no, that's it, your case is over, and you get nothing. The jury is never to go on to question number 2. If, in fact, the jury does find that your doctor was careless, now they have to evaluate whether or not his carelessness was a cause of your injury. We call that proximate cause, or causation. There must be a link, a connection between the doctor's wrongdoing and your injury. If there is no connection between what he did wrong and the injuries that you suffered, guess what? Your case is over, and the jury never gets to consider how much money you are to receive. In both of those instances, if they determine that your doctor was not careless, that's it. The jury is told, go no further. Do not answer any of the other questions. And now report back to the court. In both of those instances, once the jury determines that your doctor was not careless, that's it, your case is over. They are never to get to the next question, which is, was the carelessness a cause of your injury? But let's say they do get to the second question. They find your doctor was originally careless, and now they get to the question of proximate cause. Was Dr. Jones's negligence, his carelessness, a proximate cause of your injury? Was there a connection? Was there a link? If they find that the answer is no, your injuries are unrelated to what he did wrong, that's it. Case is over. They are to go no further. So in both instances, you get nothing. The jury never even considers how much money you are to receive for all the harms, losses, and damages that you suffered because of what you thought was your doctor's carelessness. So now, let's get back to the title of this video. If the jury determines that your doctor was not careless, yet they still felt compelled to give you $1 million for your pain and suffering, what happens then? I'll tell you what happens then. Your verdict is going to get thrown out, or at least part of it. Which part? I'll tell you which part. The part that gave you money. But now that makes no sense, right? The jury has come to a conclusion that you are entitled to receive $1 million. And now everybody in the courtroom is totally confused because they should not have gotten to that part of the issue. They should not have gotten to that part of the verdict sheet to decide how much money you were to receive if they determine that your doctor was not careless. So the very first thing that your lawyer is going to do is ask the judge to poll the jury. Now, what does that mean? It means that before the jury is sent home and thanked for their jury service, the judge is now going to ask each and every juror whether or not the answer to each question in the jury verdict sheet is what they intended. Now, why would the judge do that? The attorney wants that done because we want to make sure that whatever the jury actually intended was correctly transcribed and reported on that jury verdict sheet. Because there have been instances where the collective consensus amongst the jury was, hey, listen, we think the doctor was careless and we're going to give them money. But yet, for whatever reason, it was checked off or incorrectly recorded on the verdict sheet. So the judge has to make sure. And now the judge will ask a particular question: was Dr. Jones careless? And now, juror number 1, what do you say? Juror number 2, number 3, number 4, and he'll go down the line for all 6 jurors. And then he'll go down the line for the next question, and the next. Same thing, juror number 1, number 2, number 3, to make sure that what they intended was actually recorded correctly. There may be an instance where the jury decides, you know what, we think the doctor was careless. But for whatever reason, somebody recorded it as saying, no, he wasn't. Well, that's pretty easy to fix. All the jurors correctly verbalize that, hey, that was not our verdict, Now the judge can make the correction to the verdict sheet and again ask them collectively, listen, is that your verdict, that you believe that the doctor was careless? Yes or no? If they all say yes, well, great. Now it answers that question. And what about the question number 2? Was the doctor's negligence a cause or proximate cause of this patient's injuries? Juror number 1, number 2, number 3. If they all say yes, terrific. Now they go down to the next series of questions, which is how much money you are to receive for your damages. So in that instance, the judge could simply correct that verdict sheet. In that instance, if he were to do that, what do you think the defense would do? They would ask the judge to throw out the verdict as being against the weight of the evidence. They would argue that the jury was confused and that the legal instructions the judge gave them were confusing and improper. And then, whatever the judge decides, the defense is still going to appeal those issues, those legal issues, to the higher court, to the appellate court. Because now he's going to say, listen, this jury verdict was not proper. The jury was confused. They were confused by the law. They were confused by the sheet. They were confused among what they were supposed to do. And now this verdict does not reflect what the jury actually intended. Because by their verdict, hey, listen, they originally wrote that this doctor was not careless. So you can bet the defense is going to do everything possible to make sure the verdict stays that way. And if the judge recognizes that it's supposed to be twisted around the other way, he's now going to get upset and then appeal that particular issue. So why do I bring this up? I bring it up because inconsistent verdicts do occur from time to time. Juries do get confused by the legal instructions. Juries do sometimes get confused by the instructions on the jury verdict sheet. And sometimes there are errors of law that occur. Well, in that instance, we have the appellate court to sort it all out. As a first measure, we have the trial court to try and fix the problem before the jury leaves for the day. And if that doesn't work, now we have an appellate court to go ahead and hopefully oversee and review the legal issues to see whether or not there were any errors of law that made a difference in the outcome. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you've not yet started a lawsuit because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.